Court of Appeals, Division 1 is now in session.
Are all the lights on?
Yes.
Okay. Please be seated. Good morning, counsel.
Good morning.
Court now calls case CR150497, State of Arizona versus James Lloyd Armstrong. This is a time set for oral argument. Counsel, as I'm sure you're well aware, you both have 20 minutes to present your argument. Counsel for the appellant, is that Mr. Head?
Head, Your Honor.
Head, I'm sorry. You can certainly advise us if you want to reserve some time for rebuttal. Keep in mind that the argument today is being recorded, and it's not just being an audio recording, it's also a video recording, and we upload the arguments to our website so anyone can view it. Keep in mind we have reviewed the briefs in the case, we've conferenced the case, we're very familiar with the issues. So with that, Mr. Head.
May it please the Court, my name is Kevin Head. It's my privilege to represent Mr. James Lloyd Armstrong, the appellant in this matter. It's my intention to reserve about 3 minutes for rebuttal. The primary question before this Court is whether a defendant is entitled to rely upon the language in the indictment as the charges he must defend against at trial.
Counsel, a question I had is, how different were the charges from the indictment to the amendment? It seems to be a pretty simple case.
I believe it's a simple case that goes in our favor, Your Honor. I'm
talking about the case of the crime. It's pretty simple.
Well, to answer your question, the indictment alleged that the rifle and handgun belonged to Pioneer Pawn Shop and that the radio transmitter belonged to the hobby store, Viper Hobby Store. The amended indictment changed the ownership to Mr. Trimble as being the owner of these items. And it's our position that this substantially altered the crime by charging a distinct and separate crime by alleging a different act that these victims or the owner of this property.
How would the trial have proceeded differently if if the amendment had happened right, say 3 months before trial? What would have been done differently at trial?
That's a difficult question to answer on appeal because I wasn't a trial attorney in this case, but I can give you some options that could have changed. One, perhaps Mr. Armstrong would have pled guilty to one of the offers that he was given in this case because he would have realized that the charges reflected what the state could prove versus what they couldn't prove.
Is that proper prejudice to consider? Aren't we considering prejudice about how he would have tried the case, not whether he would have pled guilty or gone to trial?
Setting aside that argument, Judge Howe, I think that there could have been a different presentation of the defense had the amendment occurred prior to trial. Mr. Armstrong could have cross-examined the latent print examiner about whether or not his prints matched up at the pawn shop. He didn't cross-examine Mr. Briggs at all. He could have presented third-party witnesses to testify that Mr. Trimble had authorized Mr. Armstrong to sell these items.
Wouldn't those things have been useful to your client regardless of who originally owned the property?
It was unnecessary as the crime was charged. As the crime was charged, the state had charged 3 counts that it simply couldn't prove at trial. And so Mr. Armstrong should have been able to rely upon those charges, proceed all the way to trial, just as the court in Johnson acknowledged, feeling certain that his judgment of acquittal had been granted or that he would have been acquitted by the jury. And that didn't happen in this case.
This is not a case, though, where there's any confusion about what the items were or where the items originated from. His defense seemed to be all along that those items were given to me as compensation for work that I had done. Is that not accurate?
The thing is that had the trial court taken an additional step to maybe question Mr. Armstrong's attorney about how he would be prejudiced had these if the court was going to permit these amendments, we would have a different record in this case. But to ask on appeal for Mr. Armstrong to point to something in the record that he would have done differently as effectively shifting the burden to Mr. Armstrong to prove prejudice. And under Freeney, that's not required. If this were an incident where perhaps the amendment was proper as a technical or a formal defect in the amendment, or to the indictment, as under Jones, then surely it would have been Mr. Armstrong's burden to prove prejudice. But asking Mr. Armstrong on appeal to provide some kind of pointing in the record about what would have happened differently is effectively shifting the burden to Mr. Armstrong to prove prejudice, which isn't.
But Counsel, that sounds as if you're saying the very fact of error means that your client gets a new trial. And I don't think that's the law. I agree with you that if there's a proper objection, then it still has to prove that the error didn't purchase us. But the very fact of error isn't enough to warrant reversal.
And certainly Freeney overruled Sanders' prejudice per se standard, but I think the analysis in Sanders is helpful to understanding the prejudice in this case. First, the timing of the amendments to the indictment in this case, they occurred after the state presented evidence, after it rested its case, and after Mr. Armstrong moved for a judgment of acquittal. Just like in Sanders and in Johnson, this timing shows a prejudice to Mr. Armstrong's ability to defend the case. And second, you have these congruently oriented burglary charges for which he was acquitted. And so, given the specific facts of this case, I think that the standard the state needs to meet in proving that this error was harmless is insurmountable. Had there not been these burglary charges and had this amendment occurred before the presentation of evidence, we would be in a situation similar to Freeney. But it's important also to note, in Freeney, the Supreme Court noted that the trial court made a finding that there wasn't prejudice to the defendant in that case when those amendments occurred on the first day of trial before the presentation of evidence. And on appeal, Freeney argued the prejudice per se standard and that was established in Sanders. He didn't argue any kind of prejudice. In this case, we have a completely different set of circumstances. We have the amendment to the indictment occurring after the presentation of the state's case. And we have these other congruently oriented burglary charges. And so it's impossible.
And so did your client make these arguments to the trial court?
He didn't make these arguments, but he objected to the amendment, and that's all that's required of Mr. Armstrong at the trial court level. Now, had the trial court taken an additional step to determine prejudice, we would be in a different circumstance here. But we're not. That's not the record that we have.
But I guess one reason the trial court didn't make a ruling on prejudice is that your client didn't argue that, other than objecting. Correct? Am I understanding the record correctly?
You're correct in that Mr. Armstrong did not make a record of prejudice at that time. However, the trial court's actions in permitting the amendments to this indictment were completely skewed. It misinterpreted Rule 13.5b in three important aspects. First, it neglected the first sentence of Rule 13.5b, which clearly states that the trial is limited to the charges listed in the indictment. And then it skipped to the second sentence and concluded or jumped to the conclusion that surely the state had made a mistake of fact in charging these crimes. But we know from the record that this wasn't a mistake of fact. I mean, when Mr. Armstrong made his Rule 20 argument, the state defended it.
Did your client make the argument you're making now to the trial court?
Regarding what could possibly have been different, or the prejudice?
That the court was misreading or misapplying the rule?
My recollection of the record is he simply objected and said that was not proper under Rule 13.5 to amend the indictment. And the court opined that this was surely a mistake of fact, that the state had alleged that these guns belonged to the pawn shop and that the radio transmitter belonged to the hobby store. But we know that if this were a mistake of fact, when Mr. Armstrong made his Rule 20 motion, the state would have said, Judge, I think I've made a mistake here. I intended to allege that these were Mr. Trimble's guns all along, Mr. Trimble's radio transmitter. I'm moving to amend this indictment because it was a mistake of fact. And the record demonstrates this was not a mistake of fact, just as in Johnson.
I thought the state argued the pawn shop is a victim. Given that the crime is trafficking in the property of another, it's clear, everybody understands which property we're talking about, and the issue is whether it belonged to another. And if your client's defense was, this was given to me, so I wasn't trafficking in any kind of stolen property, I'm still just struggling with why that would change in any way. And it seems like there is at least an obligation to say at the time of objecting that, well, this is more than just a hyper-technical change. This affected what I would have done in a way other than I might have pled guilty prior to trial. It would have actually had an effect on on how my case is being presented.
I think it would be best practice for the trial counsel to make that record as how his litigation strategy has changed, but I don't think that under Freeney that is required.
Shouldn't we at least be able to hypothesize some error on appeal?
Yeah, and I can hypothesize with you as to what could have been different had this charge been done differently. But what we're at is that the state simply, just as in Johnson, charged crimes that it could not obtain a conviction on. And just as in Johnson, it originally alleged one theory of the crime, changed that theory, went to trial on the amended theory, and then after
what's the theory here? The theory is the property did not belong to your client. I mean, isn't that the theory? There's not really a confusion that someone else was technically the owner at one point or not. The pawn shops did own the property in theory after it was trafficked to them or after it was sold to them. So I'm not clear that it changes the nature in any way of what happened.
In paragraph 16 of Freeney, the court talks about when is an amendment substantially changing the offense to a different charge. And that includes whenever you have to prove different elements or provide different evidence of proof. In this case, in order to convict on the charges listed in the indictment, the state would have needed to present some kind of evidence that Mr. Armstrong stole those items from the pawn shop and then subsequently sold them back to the pawn shop, and the same for the hobby store. And this happens fairly frequently in cases involving shoplifting, where people go into a Walmart, for say, and sell.
Because I confess I guess I'm confused. I thought everyone agrees that the property came from Trimble, and the issue is, did I receive that property in payment for work I had done for Trimble? So I given that everyone understood that, I don't see what the prejudice is about having an error in the indictment stating who owned the property at issue. Your client's defense, assuming that it would have been successful, would have worked regardless whether Trimble owned the property or whether the pawn shops owned the property, correct?
Yes, but I think the difference here is what the court seems to be struggling with is distinguishing between a violation of Sixth Amendment notice versus a violation of 13.5b notice. And in Freeney, the court kind of refers to Sixth Amendment notice as actual notice. I think of this more of constructive notice, and that when you get the discovery, one of the things a defense attorney does is review all of the possible charges that could be brought against a defendant based on the discovery you have. You're basically constructively on notice of the charges. But when the state elects to conclude facts, as they're required to do under 13.2, as the facts they're going to prove an offense at trial, you're on actual notice of the charge. And so whenever Mr. Armstrong is presenting evidence that he was compensated for his mechanic work with these items that were ultimately sold to the pawn shop, this is easily construed as being evidence solely to the defense of the burglary charges. He didn't need to do anything to defend against the charges as listed in the indictment.
Counsel, who was listed as the victim of the burglary charge?
Mr. Trimble.
And who is listed as the victim of the fraudulent use of the credit card charge?
Mr. Trimble. And I think this is where, when you compare how the direct complaint.
Can I follow up a little bit, Mr. Head? In terms of the evidence regarding the burglary, what did the state allege? That the burglary was from a car that was owned by Mr. Trimble, or he went into Mr. Trimble's house?
The state alleged that Mr. Armstrong had access to Mr. Trimble's home through the course of doing mechanic work for Mr. Trimble, and that during the time that he was working on the cars, he learned how to use the PIN code on the garage and then enter the home. And so the state alleged on 2 separate occasions he had used that information to gain access to the residential structure and commit thefts within the home to obtain these items.
I guess my question is, if the state all along listed your client as a victim on the burglary, and the evidence from the beginning of the case was that your client stole this property from Mr. Trimble's home, and then in addition to that he was trafficking in the property, wouldn't that lessen any confusion by your client that the state was alleging Mr. Trimble was the victim and that your client stole the property and trafficked Mr. Trimble's property if the inception of the case was a burglary and taking the property from your client's home?
And I think that for Sixth Amendment purposes, notice was provided. There's not a Sixth Amendment notice issue here, and so that's why there's not a Sixth Amendment notice issue.
I guess, but you would agree that probably would help out your client to understand that he's the target of the stolen property, that it was that he was listed in the burglary charge, and that it was his credit card that was being used fraudulently, right?
It was Mr. Trimble's credit card.
Mr. Trimble's, right. I'm sorry.
Yes. And that's why I think that for Sixth Amendment purposes, there was adequate notice provided. But
what's the difference between Sixth Amendment notice and Rule 13 notice?
the Sixth Amendment notice goes beyond what's listed in the indictment and to all the discovery. And so, obviously, given what occurred prior to trial and what was known in the settlement conference, Mr. Armstrong had constitutionally adequate notice that there was an allegation that he had stolen these items from Mr. Trimble and sold them. However, when the state changed its theory from the direct complaint originally listed the owner of the handgun and the rifle as Mr. Trimble and the owner of the radio transmitter as Mr. Trimble. That changed by the time we got to the indictment. That was changed to the pawn shop and the hobby store.
You would agree that if they had done that a week before trial, you wouldn't have much of an argument. Would you agree with that?
I think I would be in a much weaker position.
Assuming we don't think there's much of an argument there, isn't the remedy, if it happens in the middle of trial and if it somehow prejudices your client, isn't it incumbent on your client to say, well, I need more time because I was surprised by this. I went to trial assuming a different strategy, and if you make that argument, then you've at least made you've got a better basis, it seems to me, for arguing prejudice, but without any kind of suggestion that I was surprised by this and now I can't go forward, or I need more time. And if that's denied, it seems like you got a great case. But without that sort of request, it sounds like it's just a technical amendment. Everybody understood what was happening, and it makes it difficult to show prejudice.
I see I'm about out of time. Can I answer your question before sitting? As to whether or not it's a technical amendment, these victims had no relationship to one another, unlike every other case where there was a victim relationship between employee, employer, agent, agency. And so this is alleging a completely different crime. So it isn't a technical amendment. As to what a best practice would be, sure, if I was the trial counsel, I would have made a different record than what Mr. Armstrong's trial counsel made. But that's not what is required. What is required of Mr. Armstrong's trial counsel is to object to an improper amendment, and that preserves this issue for harmless error review. And given the unique circumstances of this case, the timing of the amendment after the state's case, and also these congruently oriented burglary charges, that the state's burden in proving that this was harmless beyond a reasonable doubt is very difficult. And for those reasons, we're asking that this court reverse those convictions.
I know you want to have some rebuttal time, and we'll give you rebuttal time if you need that, Mr. Head. I guess the other question I have is, if if the indictment had, the way it was charged, that your client was trafficking in property that he stole from the pawn shop, is there any police report, any evidence whatsoever from the inception of the case, any of the evidence presented at trial, showing that your client broke into the pawn shop or somehow stole the property from these pawn shops?
No.
So, I mean, how on earth could your client be misled into thinking that the pawn shops were the victims if there's nothing that shows he ever took property from the pawn shop, gave them a fake ticket, anything like that?
Because that's what the state put in the indictment. And as a defense attorney, perhaps one of the best charges to defend against at trial is something the state simply can't prove.
But did your client raise the argument that I was paid by Mr. Trimble for work that was done?
Yes.
So why go into that at all if the defense is you've named the wrong party?
Because you still have the burglary charges. And the state is alleging that these guns and the radio transmitter were stolen during the burglary. And so...
And just one final question, we'll still give you some rebuttal time.
Sure.
But if your client's defense, and let's say there's only trafficking charges, if your client's only defense is, that wasn't me, I've never been in that pawn shop, that was never it could not possibly have been me. It seems like under those, we generally refer to that as kind of an all or nothing defense. I wasn't there, and it renders errors on other aspects of the case harmless. And it seems to me this is very similar. It is kind of an all or nothing. My defense was I was entitled to this property. Do you see a difference if it's just I was never there as opposed to an all or nothing defense of I was entitled to this property?
Yeah, and the court in Johnson recognized that the timing of the amendments in Johnson, which were similar here, and the shifting of theories of the prosecution, which are similar here, was enough that the error in Johnson wasn't harmless beyond a reasonable doubt. And that's the same kind of situation we have here, but we also have these additional burglary counts. And so by presenting evidence that he had permission to own these items, he successfully defended against the burglary counts. And he wasn't required to present any evidence whatsoever to defend against the charges as listed in the indictment. And for those reasons, this error shouldn't be found to be harmless.
All right, thank you, Mr. Head.
Thank you.
We'll give you some additional time. It's Mr. DeRose. Your argument?
Good morning. May it please the Court, Chris DeRose on behalf of the State of Arizona. Appellant has specifically disavowed any constitutional dimension to his claim, has specifically disavowed any Sixth Amendment problem. And what he urges on this Court, then, is almost a per se rule that a violation of 13.5 requires reversal, which is a result prohibited by our state's Constitution in Article 6 and specifically disagreed with by every decision of this Court in terms of amending the indictment. The decision of the Court that's alleged to be an error actually was unnecessary in the first instance. The rule itself permits the amendment to conform to the evidence adduced at trial. The evidence adduced at trial indicated that the handgun, the rifle, and the radio transmitter were the property of Mr. Trimble. It's important to note that the specific identity of the owner of these items is not an element of this offense. The state was simply required to prove that appellant recklessly trafficked in the property of another, which the state successfully did.
Counsel, does the record explain how this error occurred?
It does not, Your Honor. It was a decision made in the charging section at the county attorney's office, presumably, and it's never explained.
Counsel, I mean, don't you think that the prosecutor at some point should have looked at this indictment and maybe checked to see who was listed as the victim on these trafficking counts?
Absolutely, Your Honor. But that doesn't necessitate, it doesn't make the trial court's decision error, and it doesn't.
So the trial judge has got to sort all this out in the middle of trial with an error like that? I mean, I guess at some point, a defendant has a right to rely on the indictment and what the state's charged, don't they?
Certainly, Your Honor. And this Court's decision in State v. Marshall holds that simply adding facts that are extraneous to the elements of the offense, which the name of the victim was in this case, extraneous to the elements of the offense, does not make those facts an element of the offense.
I don't think adding the name of the victim is extraneous to the offense. I can't think of a single crime where it's not material to name the correct victim.
Well, Your Honor, it's not an element of the offense. It's simply, the state simply had to prove, as the statute requires, that it was the property of another. But to your point, the only way that appellant can get the remedy he's seeking today is if he proves prejudice. And Judge Catani's question to that point remains unanswered and, in fact, is unanswerable. Because from the very opening statement, appellant makes 4 references talking about, or just demonstrating his knowledge that this property belonged to Mr. Trimble in the first instance. More than any other case that this court or our Supreme Court has reviewed in concerning changes to the indictment, we have more evidence that appellant had actual notice. If you look at the memorandum prepared for the March 20th settlement conference, appellant indicated that his defense was going to be that Mr. Trimble gave him those items as compensation.
Setting that aside, what about Judge Catani's hypothetical if Mr. Armstrong had come in and just simply said, wasn't me? That was his defense. It was not me. Apart from what was said before, and if the theory of the defense was, at least in the state's case in chief, you've got the wrong guy. And that was the theory that they pursued at trial, not that the property was actually owned by Mr. Armstrong or, all the allegations, testimony regarding the relationship between Mr. Armstrong and Mr. Trimble. What if it had just been, it's not me?
Well, Your Honor, if it had been
would that be a stronger case?
Weaker case, Your Honor, if it was just an alibi defense where he said you've got the wrong James Lloyd Armstrong.
I'm saying it's not me. I didn't do it.
Didn't show up at the pawn shop, didn't show up at
I didn't steal it.
Well, his defense at trial was that this was
I know what his defense at trial was. I'm asking you, I'm trying to explore the parameters of when this type of error in a charging document constitutes prejudice.
2 circumstances. Well, okay. I'm sorry, Your Honor, I anticipated the end of your question. If it changes the underlying offense or if it causes prejudice. And so Johnson is actually a good example. Let's talk about Johnson because appellants relied heavily on Johnson. And the clear contrast between Johnson and the present case actually helps the state's argument. Because in Johnson, the defendant was able to explain when the state alleged different factual allegations, different physical acts that the defendant was alleged to have perpetrated against the minor victim, factually distinct crimes. The defendant was able to explain how it would have changed his cross-examination of the state's expert witness, and it would have changed the defendant's cross-examination of the victim when you change the indictment from penile penetration to an allegation of digital penetration. And so, by contrast, defendant has nothing but speculation to offer this court in terms of how it might have pursued a different defense. But from the outset, appellant's own words belie that speculation because in 4 instances in his opening statement, he reflected his understanding that he was accused of stealing a handgun, a rifle, and a radio transmitter that belonged to Mr. Trimble.
Now, could those arguments have been germane to the burglary count? And that defense was germane to the burglary count and not the trafficking counts?
Well, actually, Your Honor, I don't know that it would make a distinction in this case because appellant can only be prejudiced if he didn't know what he was accused of having been done and if it compromised his defense in some way.
No, that wasn't my point. My point was if he's asserting that he's the true owner of the property, could that be construed as solely a defense to, I didn't burglarize this from his house. This was my stuff. He gave it to me. And at the same time be consistent with, and as far as the trafficking and the stolen property, my defense that I'm the owner of it doesn't have anything to do with the trafficking aspect of this case. I don't know what happened to the property after that. I'm just trying to explore the parameters of how this charging document could have prejudiced the defendant and how the defense could be construed in the context of the actual charges and the defense he put on.
Yes, well,
I'm not making an argument for
certainly.
it. I'm just trying to understand it.
Certainly. And here it's hard. Judge Catani's question remains unanswered because I think it's unanswerable. It's impossible to point to anything that would have affected appellant's litigation strategy, which was dispositive to our Supreme Court's holding in Freeney, that even though we had actually, in Freeney, the state had altered the subsection of aggravated assault that it was charging the defendant under. Defendant had actual notice. There was no prejudice. There would have been no change in the litigation strategy. There is here.
And that as in this record, based on this record, you think that's the case here?
Absolutely, Your Honor. Appellant's defense was that appellant never denied that he had gone and sold and pawned these items. What his defense was that he was authorized to do so by the original owner, Mr. Trimble.
How did this error come to light?
During the Rule 20 motion, the defendant attempted, in contravention of this court's holding in Olea and in contravention of Article 6 of the Constitution, to try to secure an acquittal by a technicality. The defendant gets up during the Rule 20 motion and says, aha, the indictment alleges that the property belonged to the hobby shop and to the pawn shop, and the state hasn't proven it, and therefore I'm entitled to a judgment of acquittal.
Did he say that the attorney say he just discovered it, or?
No, Your Honor. No. In fact, I think it was almost like an ambush situation where he's looking at the indictment thinking he's got an ace in the hole, that he gets to Rule 20 and he can make this technical argument and receive a judgment of acquittal in contravention of this court's jurisprudence.
How's that an ambush?
Well, Judge Howe asked if he belatedly learned about it. It seemed as though the defendant was prepared to make that argument all along, that he was sitting there looking at what he saw as a substantive error in the indictment that would secure an acquittal for his client. Are there any other questions from the court?
No. Thank you, counsel.
Thank you.
All right, Mr. Head, we promised you could have 3 minutes. Just stand by while we get that on the clock. You're good to go.
So I think that the main issue that seems to be in dispute or the court may be having trouble with is how can an error under Rule 13.5b justify reversal when there's been adequate notice under the Sixth Amendment? And doing so, the court's looking for some proof of prejudice from Mr. Armstrong. But under Jones, the only time a defendant has the obligation to prove prejudice is if the amendment's proper in the first place. And so if it's a date of the offense or misspelling or a changing the victim from an employer to the employee or some kind of agency relationship, those amendments are all proper. And then those points where proper amendments are made, then it's the defendant's burden to prove prejudice. In this case, these amendments substantially change the nature of the offense. In State v. Bruce, the court held that or ruled that an amendment to the indictment is improper under 13.5 if it changes the nature of the offense or prejudices the defendant in any way. By changing these victims from the pawn shop to Mr. Trimble, it changed the entire theory of the case.
I'm not really following you on that, Mr. Head, because if your client from the outset, his defense was, I work for this property, this is my property, Mr. Trimble paid me for this work that I did. He stated that in his opening statement. He cross-examined the witnesses. I'm not really seeing how it's anything other than a technical error. If from the beginning he defended it as if it was his property and Mr. Trimble was wrong to claim that it was his. I mean, there's a point where form above substance has no meaning. Now, you point to some of these other cases where these defendants were severely prejudiced. The nature of the act was changed. The victim was changed. Dates have been changed. There's no way for a defendant to try to rally in the middle of trial and defend those allegations. They just don't have any. It's not just a disclosure issue. There's no time to defend. It's a Sixth Amendment right to a fair trial to present and prepare a defense. But here, if your client from the beginning and the entire record is understanding Mr. Trimble to be the victim and is presenting a defense to Mr. Trimble as the victim, why is this not simply a technical error? I mean, I understand why the trial counsel would make the Rule 20 motion. Why not? But at the end of the day, I'm failing to see That's the issue, is because your client put on a defense, he had notice. He clearly had to have had notice, or he couldn't have come up with this defense. He wouldn't have even thought. If he really thought that the pawn shop was the victim, he would have been presenting a case about, I never went to that pawn shop, I never took anything from the pawn shop. Wouldn't that have been his defense if he was fooled by this?
He wouldn't have to present any evidence if he was charged on the charges listed in the indictment. He could proceed all the way to trial, not cross-examine one witness, not present one argument, and just argue that the state hadn't met its burden proving that this property belonged to the pawn shop.
Not answering my question. I mean, there's not a single shred of evidence that you presented in your brief that your client thought the pawn shop was the victim. The entire record shows the defense that he believed Mr. Trimble was the victim. In light of that, what's the disclosure violation, what's the notice issue, and where's the prejudice?
The Rule 13.5b limits the trial to the charges listed in the indictment. And in Sanders, the court opined that a conviction upon a charge that's not listed in the indictment violates due process. In this case, we had able prosecutors charging a crime, proceeding all the way to trial under that theory. In their 15.1, they listed the pawn shops and the hobby store as victims. In their joint pretrial statement, which was designed to be read to the jury, it again elicited this theory that Mr. Armstrong had sold this property. And so
listing, the error isn't necessarily calling them victims. They are, in theory, victims. Isn't the error just saying the property belonged to, the error in the indictment was saying the property belonged to the pawn shop, but it's not error to allege, to assert throughout that the pawn shop is a victim, is it?
I think there's a misdemeanor statute that's referenced in Gagnon where if you make a misrepresentation regarding the ownership of the property, then that when you sell an item to a pawn shop, then that's a separate crime. But what we have here is simply the state charging crimes that it can obtain a conviction on at trial.
So any time the state makes an inadvertent error in the indictment of who the victims are, even though everyone understands who the victims are, then it's King's X. The defendant walks free then.
No. This case, the timing of the amendments occurring after the presentation of the case, and then these congruently oriented burglary charges. If this case didn't have the burglary charges with it, I think that we would be in a different scenario. But because we have the burglary charges and all of the evidence about Mr. Armstrong owning these items can be associated with these burglary charges, I think that makes this a very difficult issue to find that this error was harmless. Thank you.
Thank you, counsel, for your arguments. We will take this matter under advisement and will issue a written decision in due course. Court's in recess.